Hear ye, hear ye. The Colorado Court of Appeals is now in session. Please be seated.
Good afternoon, everyone, and welcome to Division 6 of the Court of Appeals. My name is Tony Navarro. To my right is the Honorable Diana Terry. To my left is the Honorable Rebecca Freire. We have two cases on our 130 docket, People v. Severson and Board of County Commissioners of San Miguel County versus Dufficy. I apologize if I mispronounced that. Counsel, please correct me when you get to the podium. Our counsel for both cases present in the courtroom. Great, thank you. I'm going to address my comments to all of you. The attorneys should have received written instructions about our oral argument procedures. When you get to the podium, please, or when you get to counsel table, please ask any questions that you have. Does either of you have questions? Looks like not. Great. I'll remind you that each side has 15 minutes, and appellant's counsel may try to reserve some time for rebuttal, but I'll leave it to you to keep track of your time with the clock on the lectern. I also remind everyone that these proceedings are being live streamed on our website and will be archived there. So please maintain the confidentiality of juveniles' names, sex assault victims, and any other information that you don't want publicly released. Also, attorneys, please identify yourself by name and attorney registration number when you get to the lectern. I ask everyone in the courtroom to turn off any cell phones or similar devices so that they will not disturb the arguments. With that being said, I think we're ready to hear arguments in People v. Severson, number 16CA0801, and counsel may proceed when ready.
Good afternoon. May it please the court. My name is Jessica Pitts, attorney registration number 48932, and I represent Jeffrey Severson. Today I'd like to talk about why the dog sniff in this case was a search and why the dog's bark was insufficient to support probable cause, for a vehicle search. So this dog sniff was a search. Now, historically, we don't consider dog sniffs to be a search because other dogs simply don't alert to things that aren't contraband. So when a dog barks, he's telling you there is contraband. So it's simply just a binary distinction. When the dog barks, there's contraband. If he doesn't bark, there's not contraband. Now, the dog in this case, Kilo, he's different. When he barks, he's saying either there's contraband in that car or there's something that a Coloradan may lawfully possess, marijuana. So the fact that Kilo does alert to something that's legal takes this case out of all those older cases saying that just like a preliminary drug test on the side of the road that tells you just whether the substance is cocaine or not, this is actually a search.
Counsel, I have a question about that. You say it takes it out of the older cases, and I'm assuming you mean the Esparza case that our Supreme Court issued. But does it really completely remove it from the analysis, or does it just lessen, is it still a factor in the probable cause analysis like Justice Boatwright discussed in his case?
So moving to the probable cause analysis, so I don't think that a dog's bark, when the dog does bark, he indicates, I don't think that that adds really anything to the probable cause analysis because in the words of Judge Jones in McKnight, the dog is just telling you there's something illegal in that car or there's something legal in that car. So that, whatever that brings, is so minimal to be really insignificant.
But I thought, pardon me for interrupting, I thought Judge Jones said that was a factor that could properly contribute to probable cause because it made it more likely that there was illegal activity going on.
So Judge Jones is applying the laws the Colorado Supreme Court has laid out in Zuniga and Cox, which is considering that dog's bark as a factor. So Judge Jones explains, though, that when there is this possible innocent explanation, the fact that there may be a lawful explanation simply adds ambiguity, and that's language from Zuniga. But Judge Jones' take on it is because there's something that's a lawful explanation, that the level of ambiguity that adds is quite significant in this case. So that to the extent we are considering a dog's bark to support probable cause to search that car, it's very minimal.
So as far as I remember, he held that it was not sufficient by itself, the dog's indication, but he did say it could be contributing factor toward probable cause. Is that right?
That's correct, and that's because the cases Zuniga and Cox that the Colorado Supreme Court decided specifically didn't answer that question. That question wasn't before them. It was before the Colorado Court of Appeals in McKnight, and Judge Jones did answer that question, that in his mind, a dog's bark alone would not be enough to supply probable cause. So, and like McKnight, this case again presents that question: does the dog's bark alone support a full-blown vehicle search?
So how does law enforcement then, are they precluded then from using a dog to determine whether a vehicle has illegal amounts of marijuana or marijuana that's intended to be distributed, which is clearly a crime even after Amendment 64? I mean, under your argument, you could never, ever use a dog to detect that. Is that what your position is?
That is my position, and to answer your question further, I'll draw an analogy to alcohol. So in passing Amendment 64, the voters specifically said that they wanted marijuana regulated like alcohol. And like alcohol, like marijuana, alcohol can be possessed illegally. If you're under 21, if you're driving with an open container, if you've got moonshine, those are all illegal uses of alcohol. But I don't think that anyone would say that alcohol is contraband, or that we could train a dog on alcohol just to double check that, you know, the person who's driving with alcohol, that it's a closed container, it's in their trunk, and that it's lawful possession. So that would be unreasonable, just because of how many people lawfully drive with alcohol, just buying it at a liquor store, bringing it home to use it.
But counsel, I appreciate that analogy, but it seems like unlike alcohol, which sometimes is legal to possess and perhaps sometimes not, marijuana in all quantities is always illegal under federal law. So whether you're in Colorado or not. So a Coloradoan driving with marijuana is violating the law, it just happens to be federal law. How do you respond to whether that contributes to the contraband analysis?
So the marijuana status under federal law doesn't affect whether it's contraband for the purposes of state law for two reasons. So first is just the plain language of Amendment 64, which says, notwithstanding any other provision of law, the following acts are not unlawful. So Amendment 64 contemplates and then disclaims the use of federal law for the analysis of whether marijuana is legal in this state. And the Colorado Supreme Court recognizes the change to the state of things caused by Amendment 64 in Zuniga and Cox. If it's true that because it's illegal federally, marijuana is contraband for purposes of searching a vehicle here in Colorado, then Zuniga and Cox would have simply said, the dog alerted, that's probable cause, we're done. Instead, Zuniga and Cox recognize that, well, there is this level of ambiguity now, and so we need these other factors.
But as you said, they didn't decide that was not, a dog's alert was insufficient alone. That they still could decide that consistent with Cox and Zuniga, right?
So that precise question has not been answered by our Colorado Supreme Court, but the Colorado Supreme Court did have to look to these other factors where under just Esparza, prior to Amendment 64, it could have just said, the dog barked, that's probable cause.
Thank you.
So I'd like to return for a second to this possible innocent explanation and just consider for a moment the level of ambiguity, the legality of marijuana adds to what the dog is telling you when it barks. So just as far as how many Coloradans are lawfully driving with marijuana, which the state informs, it says you can drive with it so long as it's in a closed container. So marijuana is a $1.5 billion industry in Colorado. And so assuming that marijuana goes for about $200 an ounce, that's 7.5 million ounces. So just imagining how much marijuana is lawfully on the road, that opens the door if courts decide that that a dog trained on marijuana can supply probable cause to search a vehicle, then there's so many cars with marijuana that really it could lead to like pretext stops and discriminatory enforcement, because the likelihood that a dog would alert to something that's lawful, giving rise to this full-blown vehicle search is quite likely. So just considering the number of Coloradans lawfully driving with it, I think just heightens what we should consider the level of ambiguity that's added here.
So assuming we agree with you and other courts that the dog's alert by itself, in this case, did not supply reasonable suspicion, probable cause to to conduct a search of the car. I think the people argued that there were also other circumstances which combined with the dog's alert, and I'm wondering if you might address that argument.
Sure. So the state argues that those factors are the fact that the vehicle yielded prior positive dog indications. It was late at night. This dog, Kilo, did indicate, and Mr. Severson acted evasively during the stop. So first off, the prior contacts giving rise to these dog indications, it was a different driver. So both the driver of this car and my client, Mr. Severson, who was the passenger, weren't involved in those prior stops. And just prior drug use is simply not enough to supply probable cause. McKnight discusses this in that case as well. The fact that it's late at night isn't going to make it more probable that somebody possesses drugs. It was 11:30 at night. That's not going to make it more likely that there's contraband or evidence of a crime in a car. And the fact that Mr. Severson acted evasively, what happened was he had a backpack in between his feet, and when they asked him to get out of the car, he told the officer that he didn't want them searching his backpack. So that's another issue that I raised in the brief, that evidence was admitted at trial as substantive evidence of his guilt. And using his saying, I want to be, invoking his right to be free from unreasonable searches and seizures, using that against him in a probable cause analysis, I think would cut down on that right by making it more costly. So I don't think relying on that is proper either. So comparing those facts with the facts of Zuniga and Cox, I mean, there really is a huge difference. In Zuniga and Cox, in addition to the dog alert, in both cases there were divergent travel plans. There was extreme nervousness. In Cox, the driver had 2 cell phones, which is indicative of trafficking behavior. And in Zuniga, there was the heavy odor of raw marijuana, which I imagine means that there was a quantity such that a human officer could smell it. So those facts are much more emblematic of criminal activity than the facts here. And in fact, I would submit that the facts of McKnight are even more suspicious circumstances than what's here. In the court in McKnight found that didn't even give rise to reasonable suspicion to sniff the car.
Thank you.
To circle back quickly to whether the sniff was a search, because the dog here, Kilo, was revealing something that that Coloradans have a reasonable expectation of privacy in marijuana, that's the reason why it was a search. Whereas the old cases, you mentioned Esparza and also Place and Jacobson, those are U.S. Supreme Court cases. Because this dog could alert to something that's constitutionally protected, that's why that's a search. Vehicle searches require probable cause, and for the same reasons I just discussed, there was no probable cause here.
Did you make that argument below that probable cause was required in order to conduct the dog sniff in the search place?
I believe trial counsel argued that it should be reasonable suspicion based on pre-Esparza case law.
Okay, so now you're changing that argument to say you need more than that, you need probable cause. And what after Esparza would give you that argument?
Just that vehicle searches require probable cause.
But that was true at the time of trial counsel's argument here as well.
Correct.
So this is an argument that wasn't raised below, although it could have been.
I would agree with that, yes.
Okay, thank you.
Yeah, just the argument that there's some reasonable suspicion or probable cause. I think probable cause would just be more consistent with vehicle search case law in general, so that's why I raised that.
Okay, thank you.
If there are no further questions, I'd like to reserve my time for rebuttal.
You certainly may.
May it please the court. Grant Feverly, registration number 42318, on behalf of the people. The activity by Kilo in this case did not constitute a search for purposes of the Fourth Amendment or Article 2, Section 7 of the Colorado Constitution. And probable cause existed to then search the vehicle based in large part on the positive indication that Kilo provided his handler while on scene. I'd like to start with the initial question of was this activity by Kelo even a search? Esparza makes clear that the framework for analysis of a dog sniff depends on the officer's right to be present at the location where the dog is deployed, and two, the legality of the detention of the thing that is seized. In the context of a traffic stop, what that means is as long as the initial traffic stop is valid and that stop is not unnecessarily prolonged as a result of the deployment of the drug dog, no additional justification is needed to then deploy that dog. No reasonable articulable suspicion or probable cause specific to the dog's sniff of the exterior odor or air emanating from the vehicle itself.
But didn't Justice Coates reach that conclusion based on the fact that people don't have a legitimate expectation of privacy in possessing contraband? And contraband, I mean, Esparza was a pre-Amendment 64 case, so didn't Amendment 64 then create that expectation of privacy in the possession of less than an ounce if you're over 21?
Respectfully, no, I don't believe Amendment 64 did create an expectation of privacy such that it would transform a dog's exterior sniff of a vehicle into a search. For a couple of reasons. If you look at the Esparza opinion itself, the court does cite to the United States Supreme Court Cabela's opinion, which talks about you have no expectation of privacy in contraband, therefore any information elicited from the dog cannot necessarily infringe on any privacy rights. However, in the Esparza case, when they're discussing the case law prior to that point in Colorado, they discussed the fact that ostensibly reasonable articulable suspicion was previously required for dog detection sniffs in Colorado. However, the language of Esparza makes clear that in all of those prior cases, what the court was actually focused on was the legality of the detention itself, not the information elicited from the dog as a constitutional violation. And that's why the Esparza language is very broad. It says that a dog sniff in and of itself does not infringe upon the privacy interests in the contents of a container. And that makes sense when you think about the real-world implications of this. If an officer initiates a traffic stop, approaches the vehicle, smells marijuana, or during the course of that stop smells marijuana, we wouldn't say that that was a search that infringed upon somebody's reasonable privacy interests. Essentially what a drug detection dog is providing is a heightened sense of smell to the officer. He's not providing information about the specific contents within the car, where those containers are located, or the interior makeup of the car itself. It's different than other uses of advanced technology that may implicate the Fourth Amendment. So for that reason, I don't believe that it infringes upon any privacy interest.
Counsel, why is it different from other enhancing technologies such as infrared technology or something which enhances a person's ability to see with their naked eye?
Sure. So again, the information provided by a drug detection dog is minimal. As Esparza says, all the indication is providing is some likelihood that contraband exists in a container within the vehicle. That remains true even after Amendment 64 for the second part of my argument, which I'll get to in a second. But if you look at United States Supreme Court case law about searches that infringe upon an expectation of privacy based on advances in technology, the opposing counsel cited the Kelo case, Kylo. That case had to do with a search of a home based on based on thermal imaging that provided information about the layout of the home that wouldn't have been visible to the officers. That's different than a traffic stop on the side of the road that's providing officers limited information, not providing them really any information beyond the fact that there's a likelihood of contraband within the vehicle, and in a car that has a lessened expectation of privacy than a home. Turning to the issue of Amendment 64, the court needs to look at what exactly Amendment 64 did versus what Amendment 64 did not do. As Judge Navarro pointed out in his questions to opposing counsel, marijuana remains illegal federally, and I don't believe that's up for debate in this case. And that's why when you read the McKnight opinion, The McKnight opinion differentiates a Fourth Amendment analysis from an Article 2, Section 7 analysis. But what McKnight did not do was it did not explore the vast circumstances in Colorado where marijuana does remain illegal. It remains illegal to possess more than an ounce. It remains illegal to distribute marijuana for money. It remains illegal to grow more than 6 plants. It did not declassify marijuana as a Schedule I controlled substance in the Uniform Controlled Substances Act of Title 18, Article 18. It did not preclude officers from launching investigations related to marijuana. While the opening proviso of Amendment 64 was quite broad, saying that marijuana should be legal, the actual enacting statute that follows restricts the right to possess marijuana to very limited circumstances. And even that permissible possession of marijuana is subject to extensive regulation that's provided in Amendment 64 and then the various regulations that have been promulgated in association with Amendment 64.
Right,
So-
but I just want to make sure we're on the same page. You agree that under Colorado law, it is legal for an adult to possess 1 ounce or less of marijuana?
Yes, but dependent on how that marijuana is being used.
Well, I wasn't talking about use, I was talking about possession only.
Well, and that's where Amendment 64 is a little bit tricky. If you're possessing an ounce of marijuana, but you sell it to a friend for $5, that would still be illegal, even if you're over 21.
Right, that's why I'm not talking about selling it. I'm talking about just possessing it. You agree that's legal under Colorado law, over 21, under 1 ounce?
Yes, but again, an individual's intent with relation to that marijuana informs whether their possession is legal or not, given what Amendment 64 provides. But what it doesn't exempt is activities such as selling to another individual or the usage in association with driving a vehicle. And I understand the court's question. As a general statement, possession of less than an ounce of marijuana if you're over 21 would not be illegal. However, you could use that in an illegal manner.
Okay, would you agree that there might be conceivably some circumstance under which it might be legal to possess marijuana under Colorado law?
Yes.
Okay, and the dog sniff will alert to that circumstance?
It could, assuming that the dog is trained to alert to marijuana.
Yeah.
So then do you agree that the passage of Amendment 64 makes a dog alert on a dog who's trained to sniff marijuana a much more ambiguous factor in this whole analysis than it once was? Or is it the same because it's still illegal under federal law?
I agree that as to the probable cause analysis, which is a totality of the circumstances test, the possibility that an individual is possessing a legal amount of marijuana is a factor that would need to be considered by the officer in deciding whether probable cause exists to then search the vehicle. I think that's a separate question than the initial deployment of the dog and what the dog can tell the officer about the possibility of contraband being within the car.
I have a question about that because Officer Martinez testified at the hearing that he had absolutely no reason to believe that there was any drug activity going on at the time he called the officer to bring Kilo to the scene. So it seems to me that he was admitting there was no reasonable suspicion of any drug activity. So how could there be probable cause to search that vehicle with just a dog, with just an alert, and nothing else, with that admission at the hearing?
Well, the officer's subjective intentions for why he did or did not call for an officer are irrelevant, frankly, for a probable cause analysis. And in this case, in that context, what's important is whether the calling of the dog unnecessarily prolonged the traffic stop. It did not here. The dog was on scene within 10 minutes, I believe, immediately alerted and then indicated, and then the search followed while the officer was still processing the traffic stop. That's one issue. The second issue goes to the probable cause to search the vehicle. opposing counsel is correct that Zuniga and Cox did not reach the specific question of whether a dog sniff alone can constitute probable cause. The United States Supreme Court has reached that issue in Harris and agreed that an alert by a trained narcotics detection dog could constitute probable cause alone. Zuniga and Cox didn't have to make that determination because in the totality of the circumstances, there were other factors that the court could look to justify the search of the vehicle. However, it did not preclude the usage and the sole usage of just a dog sniff to provide that probable cause to search the vehicle. In this case, what we have is a drug detection dog that's at the time was certified on, at the time of the motions hearing, I apologize, was certified on 5 controlled substances, one of which was marijuana, the other 4 methamphetamine, cocaine, ecstasy, and heroin, which are undoubtedly contraband. So it would be our argument that in this particular case, when the dog is alerting, the likelihood is that he's alerting to an illegal substance, one of 4 illegal substances, or that he may or may not be alerting to a legal or illegal amount of marijuana. However, that shouldn't negate the probable cause in this case. Probable cause is a common sense determination, and it's whether the facts would warrant a reasonable person to believe that the item to be searched contains evidence of a crime or contraband. In this particular case, I would argue that the search alone would provide that, given that he was trained on these other substances. If Kylo was only trained on marijuana and could only alert on marijuana, that may not be enough in and of itself without additional factors to justify a search. But in this case, you have the other substances on which he's trained, and moreover, you have this little factual wrinkle in the record that Kylo was actually being trained off of marijuana at the time of the motions hearing, and I believe at the time of trial, he had actually been completely trained off of marijuana. So there is actually a greater likelihood in this case that he was not alerting to an odor of marijuana, given the officer's efforts to untrain or detrain him.
But there wasn't any evidence in the record that he was untrained at the time that he did the sniff.
At the time of the sniff, I believe the evidence, and the record is not particularly well developed in this regard, but I believe at the time of the sniff, the officer was training him off of the substance of marijuana. However, I believe he was still certified on that substance.
So just to make sure I understand your position, you think that the dog sniff alone provided probable cause to search the car?
In this particular case, I do believe that the court could make that determination. I believe the other factors in the case provide additional support for that conclusion. It was a stop late at night. It was a stop that it was a vehicle that officers were familiar with, that previous alerts had occurred. There was no indication by any of the occupants that the substance, when the officers inquired whether they had any substances, no one volunteered that it was marijuana, which may have altered the officer's analysis in some way, that they're being candid with me that marijuana is involved here. Is that what he's alerting to, or is it something else? And you have evasiveness of the defendant upon being informed that the officer was going to search the vehicle. So all of those things in conjunction with the positive dog alert from a dog that's trained on these 5 controlled substances, I do believe provided probable cause to then search the vehicle as well as the contents of that vehicle.
Now, your opposing counsel said it would be inappropriate to consider his so-called evasive behavior because all he did was basically object to the search. And so if we use that in order to establish probable cause, that makes costly the assertion of your constitutional right. What do you say to that?
Well, in this case, it was in conjunction with the fact that he was also trying to leave the vehicle.
You mean he picked it up and got out of the truck?
That's, I believe, what the record shows, and then he ultimately remained after the officers informed him.
Right, so his only activity, I think, was simply picking up the backpack and getting out of the truck. That's the only action he took, right?
Upon being informed of the search, yes,
Yes.
I would agree with that characterization. And that goes a little bit to the second issue and the trial court's finding that it wasn't a valid invocation of the Fourth Amendment. And that's a broader question for this court, whether an individual can invoke Fourth Amendment rights when they otherwise wouldn't have
Right,
a
but
Fourth Amendment
that's
right.
assuming the police already had probable cause. What if they didn't? Could that objection, if they didn't have probable cause before then, could his objection to the search suddenly supply it?
Just that fact alone would be, that'd be a close call, I believe, for this court, if that was the one determinative fact that pushed it over the edge of probable cause. I think his demeanor and interactions with the officers throughout, though, are proper for consideration of probable cause, and did provide probable cause in this case. I'm running out of time, so I would simply ask the court to affirm the convictions.
Thank you very much.
Just a couple quick thoughts. So the state argues that the dog's bark alone supplied probable cause, citing Harris, which is a United States Supreme Court case. The dog in Harris was not like the dog in this case. The dog in Harris would only alert to contraband. This dog also alerts, Kilo also alerts to a substance that's constitutionally protected. So Harris just simply doesn't apply to this case and doesn't compel the conclusion. As to what the fact that Sergeant Folks testified that Kilo was being trained off marijuana, again, the state's correct that this was not developed in the record, and that's because counsel below asked for the field logs for Kilo to find out some of those details about when was he alerting, and they only found marijuana, and was he actually trained off. Those field logs would have revealed that trial counsel requested those and was denied, and that's another issue that I raised in my brief. I would also submit that the fact that he's being trained off marijuana just makes him more unreliable. These dogs are notoriously unreliable. There's a lot of cases talking about this. And the fact that maybe sometimes he's, that you're trying to change his behavior, I think just adds even more unreliability to this dog. I do want to touch for a second on just the cornerstone of the Fourth Amendment in Article 2, Section 7 of the Colorado Constitution, which is reasonableness. And it is a common sense concept. And I think if you asked a reasonable Coloradan of reasonable caution whether they had a privacy interest in possessing marijuana, they would tell you yes. And that's because the state tells them that they can have it. The state defends the legality of Amendment 64 before the United States Supreme Court. And the language of Amendment 64 itself says, notwithstanding federal law, this is legal. So I think to say that Colorado does not have a reasonable expectation of privacy in this substance is a problem. And if you're going to be basing searches, which this isn't a minor inconvenience, these can last up to 30 minutes. There can be multiple armed officers present. There's a dog. If you're afraid of dogs, it's a big dog. And they're rifling through all your stuff in public in front of everybody. It's not like a de minimis inconvenience. So the stakes here are quite high. In these cases where these searches are occurring, and they're not finding anything, or they're just finding legal amounts of marijuana, those cases aren't going to make it to court, and we don't know how often that's happening. So to me, it's a problem that Colorado is going to defend Amendment 64, but then say, well, we can just have free rein to search any car that someone's lawfully possessing marijuana. If there are no further questions, for the reasons argued here today and in the opening brief, I respectfully request that you vacate Mr. Severson's conviction for possession of a controlled substance and in the alternative, remand for a new trial.
Thank you. Thank you to both counsel for your arguments. They will be helpful to the court. This case will stand submitted and a written opinion will issue in due course. Counsel in this case are excused and will give counsel for the next case a few minutes to set up at counsel tables. Good afternoon, counsel. I think you were both in the courtroom when I spoke last time. Do either of you have questions about our oral argument procedures?
No, from the appellant.
No, Your Honor.
Great, thank you. I remind you to identify yourself by name and attorney registration number when you get to the lectern. And I'll again remind everyone in the courtroom to turn off any cell phones or other similar devices. With that being said, I think we're ready to hear arguments in Board of County Commissioners versus Dufficy, number 17CA1651, and counsel may proceed when ready.
Thank you.
Good afternoon, may it please the court. I'm Richard Neely, registration number 9878. I represent John Dufficy and Molly Heiser, the owner of land in San Miguel County at Slick Rock. This is subject of this appeal. In this appeal, we raise two issues before the court with respect to San Miguel County's efforts to establish a public roadway, a county road across my client's property. Those issues are first, whether or not the county has satisfied the requisite claim of right under the McIntyre versus Board of County Commissioners case by establishing notice of the claim of right sufficient to put a reasonably prudent property owner on notice of the claim. And secondly, and I think most importantly in this case, whether or not the use of the roadway across my client's property, the really undeveloped roadway across my client's property, was ever adverse because the property at all times during the prescriptive period was vacant, unoccupied, and unfenced. The county brought this action in an effort to demonstrate a prescriptive period from approximately 1967 to 1997, claiming a county road on a dirt tract that was described in the deed by which my clients took title as a cattle drive. Indeed, the evidence in the trial was pretty clear that cattle had been grazed in and about the vicinity for many, many years. It was also in the vicinity of a prior uranium mill run by Union Carbide and subsequently Umetco. However, with respect to the county's activities associated with what the county refers to as County Road S7, there's virtually no evidence of records that would have put a reasonably prudent property owner on notice of the county's claim. Now, my clients purchased the property in January of 2000, and prior to that time, from 1997 until 2000, the property was owned by Mr. David James. Before that, however, from approximately 1944 until 1997, the Red family owned the property, and in particular, the testimony of Paul Red, who owned the property and was on the property from 1957 until 1997, I think is really pertinent to the issues in this case. Mr. Red testified that he was aware of the existence of the road, although he did not testify that he ever saw any members of the public actually use the road. He testified he was unaware that there was a claim of a county road. The county's claim arises in 1967, and there are depictions of the road on county road maps from approximately 1967 until 1990, although the early maps are, and you'll see this if you review them in the evidence, unintelligible as to...
So why wouldn't the presence on the maps from 1967 up until 1997 be enough to put your clients on notice?
Well, it's 1967 to 1990, and the reason it wasn't sufficient to put my clients on notice is that the county ceased depicting the road on county maps, on the CDOT maps in 1990. Secondly,
But I don't understand why that wouldn't be enough to put your clients on notice.
Well, there's a couple of reasons. One is there's no physical evidence on the ground of any claim of a county roadway. This was an unimproved dirt track. There were no signs that it was a county road. There were old maps that showed the roadway, but it's very difficult to locate. And the reason they're difficult to locate is during the same period of time, the county's description of the location of the road said it begins in section 26. In fact, my client's property is in section 25, and the roadway begins in section 25. So a reasonably prudent property owner attempting to determine the existence of a county road across their property would not be put on notice, and particularly my clients purchasing the property in 2000 or at any time after 1990, that there was a county road, because the county had stopped depicting it on the county road maps.
Do you have any authority that it has to be continuously represented on county maps in order for it to retain its status as a county road?
I don't think, Your Honor, there is any such authority that it has to be continuously represented. In fact, there are cases, such as the Gold Hill case, where there was not a continuous representation, but where there was continuous maintenance or other factors that would put a property owner on notice of the existence of the claim of a public right-of-way. Those circumstances don't exist in this case. Once the county stopped depicting it on the maps, there was no way for a reasonably prudent property owner to investigate, except perhaps through historic investigation.
So does the county, assuming that perhaps, just for purposes of my question, that the county established a right to the road prior to 1990, is there any authority that that goes away if it's not continuously depicted on maps, or perhaps there's no continuous maintenance?
Well, I think there is authority to that effect, and I think it's the McIntyre case, because what the McIntyre case very clearly says is that the claim of right asserted by the county has to be sufficient to put a reasonably prudent property owner on notice of the claim. And what McIntyre says is that the strongest
But
evidence...
that's during the prescriptive period, right?
Correct.
But nothing in the McIntyre case talks about after the prescriptive period is over, does it?
Well, the prescriptive period in this case would be 20 years, would have taken it up to 1987. However, there was no other evidence, and as McIntyre said, the strongest evidence. And McIntyre doesn't just focus on one aspect, whether it's on a road map or a county inventory. What McIntyre focuses on is evidence that would be sufficient in toto to put a property owner on notice. And in this instance, and in the McIntyre case, importantly, they said the strongest proof of that claim is actual road maintenance. And we have no road maintenance records here, and no actual road maintenance during the prescriptive period. There was testimony from a prior highway department employee that he had helped a rancher up there clear the road at one point in time, I believe some rock, and may have gone up there occasionally. No county records whatsoever with respect to road maintenance. So I think what you have to do is not just look to one indicia, whether or not it showed up on maps at one point in time, but to whether or not there would have been sufficient evidence out there to even alert a property owner of the existence of the road. And certainly...
Counsel, I have a couple questions, though. The court found the prescriptive period was 1967 to 1987. So I'm having a hard time. So if the trial court was correct that prescriptive period established a public road, why is anything that happens after 1987 relevant to our determination? And so, Mr. Haney testified in his deposition that, yes, I was working for the county, I ordered the road grading and that kind of stuff. That's during the prescriptive period. But what I'm having a hard time understanding is why anything outside the prescriptive period is even relevant for our consideration. Because McIntyre talks about things that are happening during the prescriptive period, not outside that.
And I agree, Your Honor, the prescriptive period is what is important. However, there are no records whatsoever of any county road maintenance activity with respect to S7 during any part of the prescriptive period.
But there's testimony that there was maintenance on it. So does it really matter whether there's roads or whether there's testimony? I mean, doesn't the trial judge get to decide the weight of the evidence and whether that's sufficient? I mean,
Certainly.
I don't think we can do that, can we?
Well, no, but certainly. But
Okay.
what Mr. Haney testified about first was that he helped out Troy Rose, a rancher, clear the road. And then he said he went up there a few times in the 1980s. He didn't say what he did on the road. He didn't say that he did necessarily work on the road. And he didn't say what portions of the road, because portions of this road aren't even on my client's property. So there's really no evidence that the county activities that would put a property owner on notice of a claim occurred during the prescriptive period, other than the depiction in the map. And that depiction in the map was coupled with a description in the road inventories that was inaccurate as to the location of the road. So if you take it in together, would a reasonably prudent property owner know that there was a claim? We don't think they would. Because I'm running short of time already, I want to turn to the issue of vacant, unoccupied, and unenclosed, because I really think this is the turning point in this case. There is no evidence, none in the record, that shows that Paul Redd, who owned the property during the prescriptive period, ever used the property, ever occupied the property, ever fenced the property. The only evidence that the court relied on, and I would submit it was nominal, was that Mr. Redd had knowledge, because he saw the existence of this track in 1957, that adverse parties might be using it, that there was a bridge constructed nearby on an adjacent property owner's property, that cattle might have come onto the property, although Mr. Redd said they didn't ranch the property, they didn't use the property as part of their ranching operation, and he wasn't aware of that. And there's really no other evidence that the trial court relied on to say that this property was not vacant, unoccupied.
I thought the trial court relied on the stock tanks and Mary Randolph's testimony that she knew the Redd family. She was regularly on that property every spring, every Easter they would go up there. Her grandfather, her father drove cattle across that property regularly to get to their grazing allotments. And then you've got the remnants of this homestead cabin that I think one of the witnesses testified was in much better shape during the prescriptive period than at the time of the hearing. I thought that's what the court looked to say this wasn't vacant land. We had these fences. Mary Randolph testified about keeping the cows, the heifers that were going to be calving soon, enclosed in this, between these gates near the stock tanks. So I thought, as I read it, that's what I thought the court relied on for the vacant land exception ruling.
Well, to the extent that the court might have relied on that for the vacant land exception ruling, the court was in error. And the court was in error because the Randolphs didn't own the property.
Well, why does it matter, for purposes of whether it's vacant land or not, who it is that's occupying the land?
Well, it
Can
matters.
you give us a citation?
Well, there's not a single case out there that discusses the vacant land exception in a context other than the use of the property by the landowner.
But why is it, in your view, vacant, even though it's being used by
Well,
someone?
It's the same issue as trespass on the roadway. The fact that a third party might be using the roadway doesn't result in a loss of ownership interest to the property owner if it's vacant, unoccupied, and unfenced. In this case, the use of the property, or the traverse of the property by the Rose family would only be a trespass. And that's the same issue with respect to Union Carbide apparently inadvertently drilling 2 wells on the property and then abandoning them. The issue isn't whether or not some trespass raises or eliminates the presumption of permissive use of the roadway. It's got to be by the property owner, because it's the property owner who has to make a decision as to whether or not they want to take steps to protect their interests in the land.
So we would be making new law if we were to rule that way. Do you
I don't-
have something we could rely on?
It's simply every other case that discusses the open land exception discusses the owner's activities on the property, not someone else's activities, and it's the other party's activities that don't give rise to the prescriptive rights. So I don't think the issue has ever come up in the context of any of the cases decided in Colorado as to whether or not a trespasser's use of the land can constitute occupation of the land that prejudices the property owner's rights.
But I thought it was the public's continuous use of someone else's property that created that presumption of adversity. And so the vacant land exception has to be established to rebut that presumption of adversity rather than there being a presumption of permissive use. I think that's reversed. Doesn't the Box-Stigall case talk about that?
No, in fact, I think the McIntyre case specifically addresses that if there is a presumption of permissive use because the the land is vacant, unoccupied, and unfenced, the adverse use never arises. Adversity doesn't arise even if the length of time has been sufficient to otherwise constitute a prescriptive right-of-way. I have 18 seconds. Are there any other questions? I will not reserve any time.
Thank you very much, counsel.
Thank you. We request that the court reverse the trial court's ruling and determine that the vacant land exception in particular is applicable to this property. Thank you very much.
May it please the court, my name is Earl Rhodes. I have a registration number of 6723. Sitting at council table is Amy Markwell. She's the county attorney for San Miguel County, Colorado. I appear on behalf of San Miguel County, Colorado, and the public they represent. The issue before the court today is whether to affirm or reverse the trial court order of July 27, 2017. Based upon section 43-2-201(1)(c), the trial court held that the public now has a right of access across the property of the appellants to drive to the public lands on the west bench of Summit Canyon. A gate which the appellants locked in 2014 has been opened by order of the court in 2017. The county's argument today is in support of the trial court order since it is well supported by Colorado law and its factual findings are supported in the record. This case is about the presumption of adversity, the claim of right, and the presumption of permissive use. In the Flickinger case, the court said that the 20-year period of public use gives rise to a presumption of adversity against the landowner. In this case, the trial court found there had been more than 20 years of public use of the route of S7, which gives rise to the presumption of adversity. In addition, the trial court found that the public claim of right was first asserted in 1967 when the county included S7 in its annual public roadmap and inventory report. Based upon these findings, the trial court order is legally correct.
Let me ask you the corollary to what I was discussing with your learned opponent, and that is there any indication in the case law anywhere that the road would have to be continuously depicted on maps after the prescriptive period in order to maintain its status potentially?
No. And I would indicate further that the record shows, and the trial court found, that S7 has been on the county, has been declared or listed as a county road from 1967 through the present. Mr. Neely makes reference to county maps, but in addition to county maps, there are county inventories. There's a statutory process by which the county lists its county roads, and that's what has occurred after the maps were submitted. So as a factual matter, the county has made claim as to S7 as a county road from 1967 through the present.
Counsel, can you please address opposing counsel's argument that the descriptions of the road were not always the same during the prescriptive period?
Yes, on the inventory sheets, the road is depicted as starting in section 26, but it ends in section 25, which is where the appellant's property is. So the road description is accurate. It just starts in section 26. And the basic answer is that a reasonable person well, let me back up. Before Mr. Dufficy and Ms. Heiser purchased this property in 2000, they drove the route of S7. They crossed the bridge over Summit Creek, they turned left, they trespassed across Mr. James's property and went into the public lands. So they knew that there was a road there. And a reasonable person with that knowledge, and those people who assisted Dufficy Heiser in purchasing this property, would then go to the county and say, we see a factual circumstance where there is a road going into the west bench of Summit Canyon. What is the county's position as to whether this is a public road? And that reasonable person would have found road maps, would have seen USGS topo maps, would have seen a 1995 Colorado Gazetteer, would have looked at the statute and seen the inventory list, all of which would have shown S7 as a county road. The significance of all this is that in the reply brief, the appellants put a lot of emphasis on the case of what I call Simon 1. It's the Court of Appeals decision in the Simon case, which basically lays out the exception to the presumption of adversity when the property is vacant, lacking a perimeter fence, and unoccupied. But Simon 1 is not a public road case. And as I'm sure this court knows, if you look at the public road cases, which I have cited in the response brief, from 1984 through the present, no landowner has prevailed against the public based upon the vacant land exception. And
Counsel,
yes.
can I ask you a question pertaining to some of the earlier questions you received from my colleagues? And that is this: once the county has acquired a county road by prescription,
Yes.
is there any difference between that road and any other county road in terms of what the county has to do to maintain it as a county road?
Well, let me see if I can respond to that. First of all, this road is a little different, and this is in a remote area of southwestern Colorado, and the county listed this as a non-maintained county road. So there is no obligation for the county to do maintenance work to maintain it as a county road, although the record contains the testimony of Ray Heine that he in fact did maintain it during the period of adversity. So the county can list roads as part of the county road system that it does not maintain.
And there's no difference between how they got the road in the first place, the county,
That's right.
as to that requirement.
Right, and we're getting towards a very practical issue for counties, and particularly western slope counties, which is they may not have title to the roads they claim are county roads, and that they often rely on this prescriptive right, so to speak, in order to have a county road system. And what happens is that they represent the roads are available for public use, and the public uses them. And then at some point, a landowner says, no, that's not right, and then the county has to go to court and prove its claim under 43-2-201, paren 1C. So one answer to your question is, there are all kinds of things going on with county roads. They have deeded interests to certain roads, they have easements in certain roads, and here, by Judge Dagenhart's order, the public has a right to cross the Dufficy-Heiser property, and the county has no real estate interest in the property itself. So it's very much a mixed bag.
One of the reasons why I asked my question is I believe there are some statutory procedures that a county has to go through in order to abandon a county road.
Correct.
Would those apply to a road that the county acquired by prescription?
Yes, yes. And in fact, one of the key facts in this case is that in 2006, Dufficy came to the county and said, please vacate 2 roads on our property. One was 8.2 and one was S7. And the county agreed to vacate 8.2, but declined to vacate S7 because after several years of public hearing and an outcry from the public, the county said no. The public needs S7 in order to access the public lands. I hope I've answered your
Yes,
question.
thank you.
All right.
I want to go back to something that you were talking about, but just before Judge Navarro asked his question. It sounded like you were about to take the position that the vacant land exception does not apply in a situation where it's a county road or a public road. Is that where you were going with that?
Well, the county's argument is if you look at Colorado law over the past 40 years and you look at all the public road cases, in no case has the landowner prevailed based on the vacant land exception. And
Well, but that's one thing that they haven't prevailed, but do you have any authority that the vacant land exception does not in fact apply where it's a public road
Oh.
situation?
well, and I'm not being clear enough. The argument of the county is that in 40 years, where the county has proved a claim of right, that in no case has a landowner prevailed by asserting what I call the presumption of permissiveness, the vacant land exception. And it's a discussion of the vacant land exception is present in many of these cases. And so it is a consideration for the court. But in none of these cases has the landowner prevailed.
Understood.
And I apologize for not being as clear as I might.
That's all right. I just wanted to make sure I understood what your position was.
Thank you. I'd like to discuss very briefly Simon 2, which is the Supreme Court case following Simon 1. The appellants rely upon Simon 1 very substantially in their reply brief. But the refutation of Simon 1 is Simon 2. And in Simon 2, the Supreme Court affirmed the Court of Appeals decision, but did so on the grounds that a walking path was not a road. And in Simon 2, which came out 1 week after the Flickinger case, the Supreme Court said, this is what we're looking for in a public road case. We're looking for evidence of claim of right. We're looking for road maintenance. We're looking for roads to be listed on a county road map. And the Supreme Court said, we see no evidence of that in the Simon 1 case, which is a vacant lot in Boulder, and therefore we don't hold that it's a public road. But in the cases that follow, where there is a claim of right, the courts have all held in favor of the public's right of access to public lands. And there are numerous cases which discuss similar issues to what is present in this case, that is, a right of access across private land to get to public lands. There's a federal case, WHI, which discusses these exact issues and focuses on the landowner's petition to the county to vacate the road and indicates that that's evidence of the landowner's knowledge that it's a public road. And the trial court, in its order, says that the reference in the case law to the vacant land exception or the presumption of permissiveness is nominal. And I think that's an accurate description of the Colorado case law, because it seems that almost anything here is sufficient to overcome or take the matter out of this and to hold in favor of the right of the public.
Counsel, do you think anything that happened after 1987 is relevant at all?
You know, thank you for asking these questions, because I hadn't really thought of it that way, but I think the answer is no. I mean, I think that the appellant's argument that in 1999 they hadn't looked at maps or didn't see current maps is not persuasive. I mean, under the case law, 20 years of public use coupled with 20 years of a claim of right, and it's a public road. I would direct your attention to Boxsteigel case, in which uses on the neighboring property seem to be enough to overcome the presumption. The Cyphers case seems to be on point. This is the same type of fact situation where you have to cross private land to get the public land. And the Cyphers court found that the presence of a fence close to the property and evidence that the property was occupied or regularly used is sufficient to overcome it. We have, the key witness in this case is Paul Redd. And Paul Redd testified to two very important things. First of all, he testified that he knew the public was using the road, he took no steps to stop it, and he never gave anyone permission. So that overcomes and rebuts this vacant land exception. And the second thing Paul Redd testified to on cross-examination was that during the period of adversity, this property, the subject property, the Dufficy Heiser property, was part of his ranching operations. And so there's a use, and that's the key argument. There was use of the property during the period of adversity. So the county's request is that the trial court's order, being well-reasoned and having considered in the trial court order the vacant land exception, that it be affirmed. Thank you very much.
Thank you very much, counsel. Thank you to both counsel for your fine arguments. They will be helpful to the court, and the case will stand submitted, and a written opinion will issue in due course. That concludes our afternoon docket, and the court will be in recess, and the bailiff may so announce.